It is legally impossible to bar Trump from the presidency under Section 3 of the 14th Amendment and the Amnesty Act of 1872. In considering whether President-elect Trump could be legally barred from holding the office of president in light of Section 3 of the 14th Amendment and the Amnesty Act of 1872, it is crucial to interpret these provisions through the lens of their plain language, historical context, and legal precedents. The argument that Trump can be barred from the presidency based on the 14th Amendment's insurrection clause faces significant legal and historical obstacles that make such a scenario legally impossible. This argument is grounded in two main points. 1. The legal scope of Section 3 of the 14th Amendment, and 2. The legal effect of the Amnesty Act of 1872 under current legal standards. Section 3 of the 14th Amendment was ratified in 1868 to prevent former Confederates who had participated in the 1861 insurrection against the Union from holding public office. The section reads, "No person shall be a senator or representative in Congress or elector of president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof." But Congress may by a vote of 2/3 of each House remove such disability. And the establishment does not want you to know that this political disability was in fact removed by the Congress and signed into law by President Ulysses S. Grant just 4 years later, in May of 1872. Key elements of Section 3 include the phrase, "Officer of the United States." In 1868, this clause applied to individuals holding specific official positions within the federal government, such as members of Congress, federal judges, and officers who had sworn an oath to support the Constitution. The term did not encompass individuals holding executive roles within the federal government, such as the President, regardless of their actions. Another key element is the phrase, "As an executive or judicial officer of any state." This portion applied only to state-level office holders, such as state governors and state judicial officers. It did not apply to federal executives, like the President, or to federal officers not directly involved in state governance. While it was in effect during the Reconstruction era, Section 3 of the 14th Amendment applied only to those who held specific offices under the United States, such as members of Congress, military officers, and federal judges, none of which describes the head of the executive branch. The President, despite having taken an oath to preserve, protect, and defend the Constitution, was not an officer of the United States under the specific legal framework of Section 3. 4 years later, the Amnesty Act of 1872 was passed to remove the political disabilities imposed by Section 3 of the 14th Amendment on most individuals who had been involved in the Confederacy. The key provision of the Act reads that the political disabilities imposed by the third section of the 14th Article of Amendment to the Constitution of the United States are hereby removed from all persons whomsoever except senators and representatives from the 36th and 37th Congresses, officers in the judicial, military, and naval service of the United States, heads of departments, and foreign ministers of the United States. The Amnesty Act of 1872 explicitly removed the political disabilities for all but a few high-ranking Confederate officers. This includes individuals involved in insurrection, such as former Confederate military and political leaders who were granted amnesty and had their rights restored, unless they fell within the narrow exceptions outlined in the Act. The Amnesty Act of 1872 set a legal precedent that disqualifications for office holders involved in the 1861 insurrection could be waived or removed. The Amnesty Act removed the sanctions implemented under Section 3 of the 14th Amendment by explicitly restoring the rights of all but a few former Confederates, including many who had engaged in actual insurrection. Therefore, one of the many constitutional defenses available to Trump is that the disqualification provisions of Section 3 of the 14th Amendment may not be resurrected as to trump more than 152 years after amnesty was granted by an act of Congress. The plain language of Section 3 of the 14th Amendment applied specifically to individuals holding certain official roles within the U.S. government during the Reconstruction era, for example, members of Congress, federal judges, military officers, and never applied to the President of the United States. Indeed, the authors of Section 3 would have scoffed at the idea of applying their Reconstruction-era political disability on the President of the United States, and any purveyor of such a fantasy might well have found themselves involuntarily committed to one of the many insane asylums in operation at that time. The Amnesty Act effectively removed all political disabilities established 4 years earlier by the 14th Amendment. The legal precedent of the Amnesty Act underscores that disqualifications under Section 3 were meant to be rare and specific. Every individual who was not granted immunity under the Amnesty Act has been deceased for over a century. Since Trump has never been a Reconstruction-era member of Congress, federal judge, or military officer, his accusers fail to state a claim upon which relief may be granted under Section 3 of the 14th Amendment. Given these factors, it is constitutionally impossible to bar Donald Trump from being sworn in as president under Section 3 of the 14th Amendment. The plain language of the amendment and the precedent set by the Amnesty Act of 1872 make any such attempt both unfounded and legally unsupportable. But we must expect them to stage false flag events to start a race war or religious war or economic meltdown or even start a nuclear war. By doing this, they plan to declare martial law and hold on to power despite the election results, like Volodymyr Zelensky did on May 20th, 2024 when his presidential term ended, but he refuses to step down. Why have the graysuits built FEMA detention facilities in every state since 2020? These facilities are equipped to hold thousands, yet they are empty at this time, except for skeleton crews behind a razor wire perimeter. Meanwhile, illegal aliens are buying assault weapons under an ATF directive and living the high life on America's dime. Share this information with your friends and family. Even more important, share this with your people in the military so they know when they receive an order in contravention of their oath to uphold the Constitution. We need to get this information out there so we can stay in front of the graysuits and expose them for who they really are. As the great Alex Jones says, when we expose what they're planning before they can execute their plan, we win.